Welcome to Renters' Rights Radio.
Welcome back to Renters' Rights Radio with attorney Debi Rumph, founder of the law offices of Debi Rumph. Debi focuses on Florida tenant law and helps renters across the state navigate lease disputes, eviction threats, and the procedural traps that can quietly weaken a tenant's position before a case even begins. I'm Evan Mack, and today we're answering one of the most urgent questions Florida tenants search after opening a notice on the door. What exactly is a 3-day notice, and what happens if you ignore it? Ms. Debi, welcome back.
Thank you, Evan. I'm glad to be here.
Good to see you, Ms. Debi. So what is a 3-day notice under Florida law, and what legally happens when a landlord serves one?
Those are some loaded questions, but I'm going to start with the 3-day notice is just a piece of paper. It is just a piece of paper that the landlord or the property manager has drafted. Now, you may be asking yourself, why were they motivated to draft that piece of paper? Because that piece of paper is the landlord's permission slip to start an eviction action. It does not mean that they will start one, but it is their permission slip to start one. Now, this isn't the landlord's final word. This is the landlord clearing their throat, saying, tenant, you have not paid your rent. And as a result, I'm going to give you the opportunity to do so. Now, this isn't the actual eviction. Again, it is just the step right before the eviction. This document, if done correctly, is going to demand that payment be made within 3 days. And if payment is not made in 3 days, the landlord is asking for the tenant to return the property to the landlord.
So Ms. Debi, where do most tenants commonly misunderstand what this document actually means?
Most tenants think it means the same thing that it would have meant for their neighbor or their friend or their parents. A 3-day notice, and what happens with a 3-day notice depends on a lot of factors. When I receive a 3-day notice, the things that I'm going to start to evaluate is, who is this landlord? What is this landlord business practices? What is the landlord's goal? Do they really want the money, or do they want the tenant to leave? Then I'm going to start to evaluate the landlord's resources. Then I'm going to switch over to the tenant. Who is my client? Who is the tenant? What are my tenant's goals? How do they handle stress under pressure? Do they want to stay or do they want to go? And what are their resources? Okay, so that determines what the next step is going to be in the process. So a 3-day notice, in my mind, is the landlord forcing a decision point for the tenant. This is where I have my clients stop, reflect, and determine what their goals are so that they can navigate themselves to what the next move is going to be.
So for a 3-day notice to be legal or legally valid in Florida, what information must be included?
So a 3-day notice, again, is the landlord saying to the tenant, something wrong occurred. I did not receive my rent, and here's your opportunity to correct that. So that's all the 3-day notice is doing. And if you're not going to correct it, tenant, I want you to leave. So the things that the law requires in a 3-day notice are all the things that are going to be fair for the tenant to have in order to come into compliance. Obviously, the amount that is alleged to be outstanding needs to be in the 3-day notice. If there's no amount, the tenant can't come into compliance. So it must include the amounts. It must include the place where the tenant is to make the payment. It must include the rental address, and it must include a deadline in which for the payments to be made. Usually, it's going to say, "Hey, you have 3 days, excluding weekends and holidays," but it should also include that date, giving the tenant a clear deadline in which to make the payment.
So Ms. Debbie, how important are these dates, the rent figures, and notice language when they're drafting this?
They're huge. They're huge because, again, the tenant must be given a fair opportunity to come into compliance, right? So before a landlord runs to the courthouse to try to file an eviction, the law wants to make sure that the parties did everything they could to resolve the issue fairly before it became the court's issue or problem. So the dates and the times are critical, because if the dates and the times put the tenant at a disadvantage, then the 3-day notice is going to be held to be invalid. It's not going to do what it needs to do for the landlord's perspective. And so those items in the 3-day notice are crucial, and they're one of the first things that I look for when I get an eviction case.
So once a tenant does have this 3-day notice appear to them, how is the deadline actually calculated? Where do tenants tend to make costly, timely mistakes, Debbie?
Okay. So the way that it's calculated, I would say the landlords make more of the mistakes in the calculations than the tenants do. If you receive a 3-day notice, you cannot count the date that the 3-day notice was served. So that's number one. So if you're served a 3-day notice on a Monday, you don't start counting your 3 days until the next day. So that would be Tuesday, Wednesday, Thursday at 11:59 p.m. Right? So I tell tenants that you have up until 11:59 p.m. to get that payment in. But let's say the 3-day notice is served on a Friday. Well, you don't count Friday. You can't count Saturday or Sunday. You start the count on Monday. So if a tenant is served a 3-day notice on Friday, the tenant will have Monday, Tuesday, 11:59 on Wednesday to get that payment into the landlord. So that is how we start the calculation. You don't count the date of service. Like I indicated, you don't count the weekends and you don't count the holidays when you're counting the 3 days for a 3-day notice. You also add days for how the 3-day notice is served to you. For example, if it was sent to you via mail, there are additional days that must be added for that. If the 3-day notice requires you to mail the payment in, there are additional days that are added for that. And so that is how we calculate the days in the 3-day notice. Did I answer your question, Evan?
Yes, Ms. Debbie. So if a tenant believes the amount demanded is wrong, inflated, or includes charges beyond rent, then what should they evaluate before responding?
The biggest thing that should be evaluated is the rent ledger. Okay, some people call it the rent roll, and these documents generally are in the tenant's portal. Okay, so that's the first thing we look at is the rent roll, understanding what has been charged to the tenant, what has been paid or acknowledged as paid. The second thing that tenants should evaluate is their lease. Are these charges authorized by the lease? If they're not authorized, then you can't charge them. Also, looking at communications between the tenant and the landlord is a huge one. And the biggest thing that we want to evaluate is whether the amounts that were charged are additional rent under the lease or not.
So Ms. W, what usually happens when a tenant ignores a 3-day notice completely?
An ignored 3-day notice is absolute gold for the landlord. That is exactly what they want. If a tenant fails to respond to a 3-day notice, what that is saying is that the tenant has no intent on correcting the failed payment. As a result of that, the landlord moves forward to the next step pretty quickly. If a 3-day notice was filed on Monday and it expired on Thursday, by Friday they're filing the eviction because they've not heard anything from the tenant and they believe that the deficiency is not going to be corrected. So when a landlord meets a 3-day notice in silence, they generally tend to escalate the case to move forward faster.
Mm. So how quickly can that, move this notice and this stage into the court, from the eviction notice to court?
Again, if notice expires, once that notice expires the next day, the landlord is authorized to file an eviction. I see this more with sophisticated landlords, apartment complexes, big institutional landlords. They move very quickly. 3-day notice expires, the next day the file is with their attorneys. So it can escalate pretty quickly and be in court pretty quickly if a response is not made or if an attempt to negotiate is not made. It could escalate pretty quickly.
So with that being said, Ms. Debbie, at what point does the tenant's leverage begin shrinking?
Leverage shrinks at every stage of the game. Every stage. Let me give you an example. If there is a failure to pay rent, normally a tenant knows that down the pipeline before the rent is missed, right? If a tenant starts to strategize as soon as they know that there's going to be a problem in the future, there's a lot of leverage there. But if you wait until the rent payment is due and the payment is not made, and then if you wait again, so the leverage is starting to shrink. If you wait until you get a 3-day notice, we're shrinking. You let it 3-day notice expire, we shrink again. The lawsuit is filed, we shrink again. You allow a final judgment to be entered, we shrink again. You allow the sheriff to show up at the door, there's more and more shrinkage at every stage of the game. So shrinkage starts when you know you're not going to be able to make the payment and you don't take action to do something, come up with a strategy or a plan. The sooner you start strategizing and putting a plan together, the more control and the more successful you're likely to be to navigate the situation. But it starts the moment you know you can't pay rent and you take no action.
With that being said, after that 3-day notice is received, what defense, procedural arguments, or strategic options might still be available to a tenant?
Lots are still available. Now, it's going to depend. As I indicated earlier, what generally happens next depends on a lot of factors from the landlord and a lot of factors from the tenant. The biggest factor of what happened next tends to be whatever the tenant's goal is and the tenant's resources. So there are lots of strategies and opportunities that are available, but they depend on a number of factors, including a number of factors coming from the tenant side, which are goals and resources.
If a dispute, may escalate beyond the notice stage, what documentation should tenants begin gathering immediately?
Well, this is a tough question because I would hope we're not. I hope we're gathering documents and keeping track of everything when there's no dispute, right? I highly recommend that tenants keep a cloud account and they just save communications and proofs of payments routinely when the relationship is good. But certainly when the relationship turns sour, the tenants, you're going to want to have proof of all of your payments under your current lease. When a landlord claims that they have not received all of their payments, that triggers go all the way back to the first payment under the lease to present day. So you want to make sure that you have all of your payments. You're going to want to make sure you have a copy of your lease. Now, again, you want to make sure you have a copy of the lease when the relationship is good, but you surely want to make sure you have a copy of that lease as disputes are arising. You want to make sure that you keep records outside of the landlord's portal. I have witnessed when tenants have disputes with their landlord, things in the portal start to disappear and they start to change. So when the relationship is good, you just want to have a habit of saving those communications outside of the portal. Certainly when the relationship goes sour, you also want to make sure you move all of your communications out of the portal to preserve what happened. You also want to make sure you have receipts for your payment. Now, obviously, if you did electronic payment or a check, the bank is going to be instrumental in proving your receipts. But what if they're cash payments? You want to make sure you have receipts of those payments. The burden of proof in an eviction for non-payment of rent is on the tenant to prove that they made all of their payments. And if you make cash payments and you don't have receipts, it's going to be very difficult in court. And finally, you want to save all written communications and you want to memorialize your oral communications in writing. What bites tenants the most in eviction cases is they'll have all of these conversations that they had with the landlord. And those conversations are not in writing. So even though we can solicit that information in court, usually opposing counsel, the landlord's counsel is going to object on the basis of hearsay, and the hearsay exception will rule out a lot of that evidence. And so you want to make sure that you have all of your written evidence together as well.
All right, Ms. Debbie, we're running a little low on time, but I did want to get to a couple of the follow-ups after this question. Are there common quick fixes that typically backfire when it comes to this 3-day notice situation for tenants?
So quick fixes are announcing, I'm going to sue you. I'm going to get an attorney and we're going to fight it out. Those tend to backfire pretty quickly. As you could imagine, if you start a fight with an employee of the landlord who is represented by counsel, and this is what they do all day, every day, they tend to be a little bit more skilled than the tenants in navigating the system. And that's the biggest backfire that I see. If you're getting a 3-day notice and you have not paid the rent, at this point, you want to use more honey rather than vinegar, and not escalate a fight with the landlord at this time.
So, Ms. Debbie, when does waiting too long become its own legal problem?
Waiting too long always becomes its own legal problem because, as I indicated, the more you wait, the less and less options and strategies and leverage you have. So I have to evaluate what options you have at each stage. And so waiting longer always reduces your options and strategies. So that's when it becomes a legal problem.
So can you walk us through a situation where a tenant initially underestimated that 3-day notice and how timing and documentation or strategy changed the outcome?
Yes, I can. We had a case, it was a repair dispute. The tenant, Googled, what to do when you're having a repair dispute. And Google told her you could withhold the rent. And so she did so. She withheld the rent because there was raw sewage coming out of the kitchen sink. And the landlord responded with a 3-day notice. She gave the 7-day notice. She started withholding rent as is required by the 7-day notice. Well, she got a 3-day notice and she was like, they're bluffing. There's no way they're going to try to evict me. I've been complaining for months about this raw sewage. This 3-day notice, they're bluffing. They're not going to do anything. Well, they filed the eviction. And that's when she contacted us and we, yep, they could file the eviction. They gave you a 3-day notice. But we evaluated the 3-day notice. There were mistakes in that 3-day notice. So we got the 3-day notice invalidated. And then we took her repair documentation and then we served the landlord with a 7-day notice. And so that strategy and documentation changed the entire nature of the eviction case. And we were able to settle that case favorably for the tenant in that situation.
Ooh, that's good stuff, Miss Debbie. Thank you so much for your time.
Thank you, Evan.
All right. That wraps up today's episode of Renters' Rights Radio with attorney Debi Rumph. Visit DebiRumph.com to explore Debi's tenant-focused legal services and learn what options may still be available to you. Thanks for listening, and don't forget to like, subscribe, and share this episode with someone who may need clarity before a deadline runs out. We'll see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.